Qualified immunity is a legal principle in the United States that provides protections to public officials for personal liability under certain conditions. This principle is particularly relevant to educational administrators in the public sector because it safeguards you while performing your duties, provided you are acting within the boundaries of your role and not violating clearly established legal rights. The term qualified in the qualified immunity means that this immunity is conditional, not absolute. It's granted only when your actions are consistent with your professional responsibilities and do not infringe upon well-defined statutory or constitutional rights. By contrast, absolute immunity provides complete protection from liability for certain actions, regardless of whether those actions violate someone's constitutional rights or not. This type of immunity is typically limited to specific roles and scenarios to ensure that certain functions of government can be carried out without fear of personal litigation. For example, judges are often granted absolute immunity for actions performed in their judiciary capacity. This immunity covers decisions and actions directly related to the judicial process, ensuring that judges can perform their duties without fear of personal lawsuits. If a judge decides to release someone from jail and that individual then commits a crime such as a murder, the judge would not be personally liable for that decision. This is due to the principle of judicial immunity, a form of absolute immunity which protects judges from personal liability for their official judicial capacity. This does not mean there are no checks on their power. Judicial decisions are subject to appellate review, and judges can be disciplined or removed for misconduct or failure to comply with judicial standards. Let's come back to qualified immunity. Proponents believe that this legal protection is essential for administrators and educators to perform their roles effectively without the constant worry of personal legal challenges for every decision they take. Opponents of qualified immunity argue that it can create barriers to holding public officials accountable when they do infringe on individual rights. The controversial nature of qualified immunity had led to calls for reform or abolition. The ongoing debate around qualified immunity is part of a broader conversation about how to strike the right balance between protecting public officials from frivolous lawsuits and ensuring that victims of public officials' misconduct have effective legal avenues to pursue justice. Let's look at some cases about educational administrators' qualified immunity. Imagine you are a school principal. If a parent or student believes your decision violated their legal rights and decides to sue you, qualified immunity can come into play. This protection means that you won't be personally liable for damages. That is, you won't have to pay out of your own pocket unless you violated a clearly established legal right that a reasonable person in your position would have known about. Clearly established, it's a key term in qualified immunity. For example, if you are grappling with decisions about how to handle cyberbullying among students, managing student data privacy on online learning platforms, or setting policies around transgender students' policies, those are areas where the law may not provide black and white answers. The laws are vague and are not well defined. You may receive qualified immunity because it's unreasonable to expect you to know you are violating a right. In this case, qualified immunity offers some leeway, allowing you to make reasoned, albeit possibly incorrect decisions on those unsettled legal questions without the immediate threat of personal liability. In Safford Unified School District No. 1 v. Reading, 2009, Wilson was an assistant principal. he took a 13-year-old student, Savannah Reddy, from her classroom to his office. He showed her a day planner that had knives and other contraband. The student admitted the planner was hers, but claimed she lent it to a friend and the items were not hers. The assistant principal then found strong prescription and over-the-counter painkillers, which were not allowed in school without prior permission. The student said she did not know about the pills. Despite her denial, the assistant principal said he had a report that the student was distributing pills to other students. The student then allowed a search of her bag, but they found nothing. The situation escalates when the assistant principal asked an administrative assistant to accompany the student to the nurse's office to search her clothes for pills. The student was asked to remove her outer clothing and to shake out her bra and pull her underwear elastic, somewhat exposing herself. They found no pills. Following this, the student's mother filed a lawsuit against the school district, the assistant principal, the administrative assistant, and the nurse, arguing the strip search violated the student's Fourth Amendment right, which protects the privacy and security of individuals by prohibiting unreasonable searches and seizures by government authorities. The two questions here are, did the strip search violate the student's Fourth Amendment right? Were the school officials in this case protected by qualified immunity? Let's look at the first question. Did the strip search violate the student's Fourth Amendment right? The court ruled that the search was unjustified. A search by school officials must be justified at its inception. This means there must be reasonable grounds for suspecting that the search will uncover evidence that the student has violated or is violating either the law or the rules of the school. In this case, the suspicion was based on the report that the student was distributing pills. A less intrusive search, such as examining the student's backpack and outer clothing, may have been considered reasonable given the nature of the suspected infraction, that is, possession or distribution of pills. However, the evidence was not strong enough to warrant a highly intrusive search, such as a strip search. The pills found in the planner, which she admitted to owning, were not in themselves sufficient to justify a strip search, especially given her lack of a prior history of such behavior and the non-dangerous nature of the pills. Justified strip searches, particularly in the context of school environment, are very rare due to the highly intrusive nature of such searches and the special protections afforded to students. Strip search are often justified when new inmates enter a prison or detention facility to prevent the introduction of weapons, drugs, or other contraband into the facility. Law enforcement may conduct a strip search if there is a reasonable suspicion that an individual is concealing weapons or contraband that poses a direct threat to the safety of officers or the public. For example, during an arrest, if an officer has specific intelligence or evidence suggesting the individual is hiding a weapon or illegal substance on their person, a strip search may be justified. Moreover, at borders or customs, a strip search may be justified if there is reasonable suspicion based on specific intelligence or behavior indicating that a person is smuggling contraband, such as drugs, across borders. For example, a traveler matches the profile of known smuggling methods or has been flagged by investigative methods. In educational settings, a strip search is generally considered excessive. However, in some extreme cases, strip searches may be justified when there is credible evidence suggesting a student is carrying a weapon or highly dangerous substance that pose an immediate threat to the safety of the school. However, such situations would be exceptionally rare and subject to stringent legal scrutiny due to the protected status of students. Now let's look at the second question. Were the school officials in this case protected by qualified immunity? Despite finding a Fourth Amendment violation, the U.S. Supreme Court granted qualified immunity to the school officials. The court noted that the law was not clearly established at the time of the search in such a way that a reasonable school official would have understood that the strip search violated the Fourth Amendment. This was partly due to the lack of a precedent with sufficiently similar circumstances. This case underscores that it's important for educational administrators to stay informed about the latest legal standards. It's advisable to routinely evaluate and update school policies to align with current legal precedents. This proactive approach not only ensures legal compliance, but also creates a more respectful and rights-conscious school environment. Here is another case about educational administrators' qualified immunity. In the case of Baird v. Board of Education School District Number 205, 2004, Kelly Baird was hired by the Warren County School District Board of Education, Illinois, to serve as superintendent under a 3-year contract that provided he could be dismissed only for cause. During his tenure, certain board members collected negative comments about him and his activities from secretaries, teachers, and other district employees. Those comments then began to appear in the superintendent's annual performance review. On April 18, 2001, the school board presented the superintendent with its evaluation of his performance and a letter that notified him of its intent to terminate him for cause for the reasons noted in the evaluation. The superintendent was also given a date for a hearing, which was in less than a month. After the superintendent received the letter about his potential firing, he quickly contacted his attorney, who then wrote back to the school board, asking for several things: more time before the hearing, access to all underlying documents related to superintendent's job performance review, the names of people who had given feedback about the superintendent, and for board members who seemed biased against the superintendent to not be involved in the decision. Here, the underlying documents refer to all the paperwork, records, reports, and any other written materials that form the basis of the school board's evaluation of the superintendent's performance and their decision to consider terminating his employment. This would typically include performance reviews, any complaints, notes, or minutes from meetings where the superintendent's performance was discussed, and possibly feedback or statements from other employees, teachers, or staff. Essentially, those documents are the evidence or source material that the board relied on to reach their termination decision. The superintendent's attorney requested those documents to better understand the reasons for the superintendent's potential termination and to prepare for the hearing. However, the board denied all the requests. The board also stated that they would not call any witnesses, would not review identities of the individuals whose claims had provided the substance of the performance evaluation, or could not make any school employees come to the hearing. The superintendent was only entitled to notice and the opportunity to be heard, and he could only ask board members about things they had already talked about. On the day of the hearing, the superintendent's attorney sent one more message before the hearing, arguing that the way the board had set up the meeting was unfair. That evening, the superintendent went to the hearing with his attorney to express his concerns about how the board was breaking the contract and not following procedural due process. After making his point, he left. The board then went ahead with discussing whether to fire the superintendent, and as expected, they voted to terminate the employment. After this decision, they sent the superintendent a formal notice saying that he was fired. The superintendent did not think he had a fair chance to defend himself, so he filed a lawsuit against the school board, arguing that the board breached the contract and the way the board fired him was unfair and did not follow procedural due process. Did the school board violate the procedural due process? Did the board members have qualified immunity? Let's look at them one by one. First, the superintendent was fired in the first year of a 3-year contract. His contract specified that he could only be dismissed for cause. This meant he had a property interest in his continued employment, which required procedural due process and a thorough pre-firing hearing. The superintendent had the right to a meaningful chance to be heard before being deprived of a job. In this case, one of the main problems with the hearing was the lack of transparency. The superintendent was not given information about who had provided negative feedback against him. In a fair and just process, an individual facing termination should be able to know the source of the complaints or allegations against them. The school board denied the superintendent the opportunity to fully understand the case against him and to respond effectively. Think about it. If you were the superintendent, without knowing who gave you negative feedback, it will be difficult for you to put up a strong defense. You won't be able to address the criticism or clear up any misunderstandings without knowing who provided that feedback. The school board's hearing seemed to have been more of a procedural formality rather than a genuine opportunity for the superintendent to defend themselves. Procedural fairness in such hearings typically requires that the accused be given a reasonable opportunity to present their side, including challenging evidence and cross-examining witnesses. Under the principle of the due process, especially in the context of public employment, there is an expectation of a fair and meaningful hearing before any adverse employment action is taken. The deficiencies in the hearing process, particularly the lack of detailed information provided to the superintendent, suggest a failure to meet the due process standards. Move on to the second question. Did the school board members have qualified immunity? The court decided that the school board's actions did not qualify for this protection. This is because the due process rights of public employees, especially regarding termination, have been clearly defined in many court cases. I have an entire video introducing employment as a property interest. If you need to refresh your memory, check out my previous video. In this case, the school board, as a public entity, should have been aware of the legal requirements for due process in termination procedures. A reasonable school board should have known that their hearing process was not legally adequate because it lacked transparency, fairness, and adequate opportunity for the superintendent to respond to allegations. Qualified immunity is intended to protect public officials who make reasonable mistakes about what the law requires. In this case, the school board's mistakes was not reasonable because the legal standards were clearly established. Similar cases had been consistently ruled a violation of due process rights. The precedents reinforce the idea that the school board's actions were in violation of a clearly established right of procedural due process. I'd like to add something about the underlying documents that the school board denied the superintendent's access to. It's very common for an attorney to request underlying documents in situations similar to the case I just introduced. This is a fundamental part of due diligence and preparation for hearing, especially in cases involving employment disputes, contractual disagreements, or any other scenario where a decision or action is being contested. In similar situations, a superintendent or any employee facing termination or disciplinary action can request the underlying documents on their own. If you choose to do so, there are a few things you need to keep in mind. First, you should review your employment contract and the employer's policies and handbook. Those documents often outline the procedures for disciplinary actions, including what documentation the employee is entitled to. Second, the request for documents should ideally be made formally in writing. This establishes a clear record of the request and can be important if there are later disputes about the transparency of the process. Third, be specific about which documents you are requesting. They can include performance evaluations, complaint, meeting minutes, correspondence, and other records related to the employment and the decision to terminate. Fourth, if you have a legal representation, it's often more effective to have an attorney make the request. An attorney can ensure that the request is properly worded, legally sound, and covers all necessary types of documents. They can also deal with any refusal or negotiations regarding document access, because the employer may refuse to provide certain documents citing confidentiality or other reasons. In legal proceedings, both parties should have access to the evidence and information that will be used. And this ensures fairness and allows for a thorough examination and defense. Given the importance of the underlying documents, it is critical for educational administrators, like other professionals, to maintain and manage records and documents with a certain level of diligence and foresight. Good record-keeping practice are essential for educational administrators to ensure efficient management, compliance with legal and regulatory requirements, and prepare for any audits or legal issues that may arise. As administrators, you should always seek and document evidence or first-hand accounts when dealing with issues that might lead to disciplinary actions or other significant decisions. You should build a culture where employees feel comfortable reporting issues directly rather than through the grapevine. Very often, employees resort to using the grapevine or informal communication channels to share information or discuss issues. They feel that the formal channels of communication are inadequate or when they fear potential repercussions for speaking up. It's also important to provide training for employees on appropriate communication protocols and the importance of direct, evidence-based communication. When reporting an issue, employees should be encouraged to provide evidence to support their claims. This approach ensures that any reported problems are substantiated and credible. Educational administrators should also adhere to principles of fairness and legal caution in your communications and documentation. You should avoid unsubstantiated accusations in your communication. Making accusations without solid evidence can lead to legal challenges, including defamation lawsuits. It's both legally prudent and ethically responsible to ensure that any accusations or critical statements you make are backed by verifiable evidence. You should also refrain from repeating hearsay or information received from others that you cannot adequately substantiate. For example, you're a supervisor and you give an employee a poor performance review. This review is solely based on negative remarks from the employee's coworkers. However, you have not personally seen any of the poor performance you are mentioning in the review yourself. You're just going off the second-hand reports that others have told you. Moreover, you did not ask the people who made those negative comments for any proof or details to back up their claims. In legal context, hearsay is often not admissible because it's not considered reliable evidence. Similarly, in administrative decision-making, hearsay should not form the sole base for significant decision. That employee may pursue legal action against you, claiming unfair treatment or discrimination. This is especially likely if the performance review you produced influenced their employment status, such as in cases of demotion, denial of a promotion, or termination. In this video, I introduced educational administrators' qualified immunity. It is important for administrators to stay informed about the latest legal standards. This is because your mistakes are protected by qualified immunity only when there is no clearly established legal standards. Therefore, staying updated with the current laws and court rulings is essential to ensure that your actions align with legal requirements. Remember, qualified immunity does not cover actions that violate well-known legal principles. By continuously educating yourself with those standards, you can make informed decisions that uphold the rights of others and protect yourself legally.